My name is Jenny Torres, and today I'm going to guide you through a very interesting defamation cases that changes today's law studies. The part number 1 will be New York Times versus Sullivan. The parties of this case were L.B. Sullivan, one of the 3 elected commissioners of the city of Montgomery, Alabama, who alleged that he was liable by statements in a full-page advertisement carried in the New York Times on March 29, 1960. The New York Times Company is the defendant, a New York corporation that publishes the New York Times, a daily newspaper. Petitioner, the New York Times Company, published an advertisement in its March 29, 1960 issue that mentioned Sullivan by position but not by his name. Sullivan sued for libel in an Alabama trial court, alleging that he was a victim of libel, and the Alabama trial judge declared the advertisement to be libelous per se, and that the only question was whether the petitioner published the advertisement and that the statements were made concerning the respondent. Sullivan alleged that the advertisement entitled "Heed the Rising Voices" included statements which some of them were false, claiming that this declaration referred to him because his duties included supervision of the police department. Sullivan felt that this statement would damage his reputation and also cause irreplaceable relationships with other public officials, protesters, and also with his community. As some of the events stated in the advertisement have not been proven to be untrue, Sullivan felt that all of the things that were mentioned in the ad about the police officers would reflect on his own character as well. The advertisement included statements of which were false about police action allegedly directed against students who participated in civil rights demonstrations and against a leader of the civil rights movement. Right now I'm going to read the elements of defamation as I found it on the official document. There were no reference to respondent in the advertisement, either by name or official position. A number of the allegedly libelous statements, the charges that the dining hall was padlocked and that Dr. King's home was bombed, his person assaulted, and a perjury prosecution instituted against him, did not even concern the police. The jury found for respondent and the state Supreme Court affirmed. A state cannot, under the First and the 14th Amendment, award damages to a public official for defamatory falsehood relating to his official conduct unless he proved actual malice, that the statement was made with knowledge of its falsity or with reckless disregard, or whether it was true or false. Part number 2, Gertz versus Welch. The parties of this case were Elmer Gertz, which is the petitioner, a reputable attorney that represented Nelson's family in a civil litigation against a police officer named Nuccio; Robert Welch, the respondent, a magazine publisher who worked at the American Opinion, a monthly outlet for the views of the John Birch Society. The petitioner was neither a public official nor a public figure. In 1969, the respondent, Robert Welch, publisher of the American Opinion, ran an article in which accused the petitioner of being the architect of a frame-up Nuccio. The article stated that the petitioner had a criminal record and a long history of communist affiliation. The petitioner filed the instant case for libel, and after trial, the jury returned a verdict in his favor in the amount of $50,000. It labeled Gertz as a Leninist and as a communist frontier. It also stated that Gertz has been an officer of the National Lawyers Guild, described as a communist organization that probably did more than any other outfit to plan the communist attack of the Chicago police during the 1968 Democratic Convention. Robert Welch failed to investigate the veracity of this allegation. Also, the managing editor of the American Opinion made no effort to verify or sustain the charges against petitioner. Instead, he appended an editorial introduction stating that the author has conducted extensive petitioner and wrote the caption that appeared under it. Elmer Gertz of Red Guild harasses Nushu. I believe this allegation not only hurt his reputation as a private person, but also in his professional career as an attorney. The petitioner filed a diversity action for libel in the United States District Court for the Northern District of Illinois. Gertz claimed that the falsehood published by the respondent injured his reputation as a lawyer and also as a citizen. In this case, I will have verified the information before writing something that is highly accusing to someone. It is a matter of professionalism and ethics not to write something without verifying first if the allegations are true. The things that we as journalists write can harm someone's life and ruin their reputation if we are not careful with our words. Right now I live in Puerto Rico, and here there are only civil laws for defamation as per now. In 1974, Puerto Rico enacted a criminal defamation statute in Articles 118 to 121 of the Penal Code, which included libel, through as defense, report of official acts, and diffusion of conviction. But in the year 2000, the criminal defamation statute mentioned in the Penal Code was defeated by decision of the Court of the First Circuit in Boston. Since Puerto Rico is a Commonwealth of the United States, some of the decisions are based on the Supreme Court of Puerto Rico. Currently, in the island, there are only civil laws for defamation. In Puerto Rico, what governs defamation and libel is Article 1802 of the Civil Code and is resolved by the Supreme Court of Puerto Rico and others by the Supreme Court of the United States. The Act 149 of June 18, 2004 adopted a new penal code of the Commonwealth of Puerto Rico. This act repealed the penal code which ruled in our island since 1974. The penal code eliminated Article 118, defamation, which criminalized directed to dishonor, discredit, or impute the commission of illegal acts and changed the honesty, integrity, virtue, or reputation of any natural or that conduct legal or denigrate the memory of a deceased. I have learned a lot from both of these cases. One is to be aware of the responsibility that I will be having over my shoulder as a communicator. Also, the importance of checking facts, verifying the information before assuming something that can be damaging in any way of a public or a private person. It doesn't matter. You need to be aware of what you write, what you say that can be very, very, very hurtful to someone's reputation. I hope this can help you as well, and you find it very entertaining as I did. It's pretty amazing to see how these cases can relate to your history and how can impact your life. Thank you.